Um, Chitra. Can you hear me, Chitra? Acha, yeah. So for the that GI filing, for some of these things, I think will be needing your help because there's some issues that is coming up.
Okay,
So
we'll speak later.
We will need your inputs in that also.
Yeah.
Good morning, ma'am.
Hi, good morning. So nice to see you.
Hi, Shika. Long time.
Good morning, ma'am. Nice to see you.
You too, Shika. It's such a pleasure to meet you online.
Always. Yeah, it's always nice to hear from you and learn from you.
No, ma'am. Dr. Shika is such an expert in patent.
No, ma'am. You are being too humble.
Morning,
Hello,
good
sir.
morning to all. Yeah, nice to see you all feeling like a family on Ganesh Chaturthi.
Good morning, sir, and heartiest wishes to you.
Yeah, good morning, sir. How are you?
Good, fine. How are you?
Yeah, I'm doing good. I'm so happy to see you all.
We are celebrating.
Connected and to be in one platform like this.
Yes, that's the technology. And that's where we have to progress. If we have to develop nation by 2047.
We should be, pandemic, one of the positive is that now everybody knows how to use the online platform like this, where we can be connected and all, So with the pandemic, we have learned to use all these technologies. So
great.
Dr. Nesatele, I think you can start the session.
Oh, okay. Has all the speaker joined?
Yes.
Siddhartha.
Yes.
Hi. Good morning.
Good morning, everyone. Good morning, ma'am. Thank you for having me.
A pleasure.
1 or 2 minutes. Okay, I'm here. Good morning to everyone.
Right.
Anwar sir is also there. Good morning, sir. I'm here, madam.
Okay. I think if all the speakers has joined, then I think we can start. Pele, shall we start now?
Yes, please, ma'am.
Okay, so a very good morning to all of you and greetings to you all from Bhopal. Right now I'm in Bhopal attending the DST meeting, but nevertheless, So on behalf of the Nagaland Science and Technology Council, Department of Science and Technology, Government of Nagaland, I welcome all the officials of the DST Government of India, all the state S&T councils, the invited guest speakers, and all the participants to today's program. Today, we are happy to have the eminent speakers, the experts from different sector who are going to give a talk on the intellectual property rights. Am I audible?
Yes, very much. Yes.
Okay. So today, I'm happy to say that today's program, this one we have designed in such a way based on the state requirement, the need on the state. On the need basis, we have designed this program. And I'm so happy that when we invited all the speakers, they are happy to join and they have agreed to give a talk. And today we have a prominent speaker, Dr. Yashwant. He is a scientist F and head of Patent Facilitating Center at TIFAC. He did his PhD on IP and standards, and he holds a degree on MTech in future studies and planning. And he has been working more than 23 years for PFC in different capacities. So PFC, under his initiative, PFC has been facilitating filing of patent application on behalf of the academic institution and government R&D institution, creating the awareness on IPR in different parts of the country and giving the policy input to the government. And he has conducted a number of IPR training, patent search, and other IPR and WDT issues. And he has facilitated more than 100 patents and other IPRs in the country. And Sir is the one who always is there and give the technical guidance to all the state PIC. And Sir is the one who is always there to support us and maximum support to the Patent Information Center Nagaland. So I'll just briefly to those who are not aware of it, I'll just briefly highlight what is the PFC. So PFC is the Patent Facilitating Center. This is set up in the year 1995 by the Department of Science and Technology as a unit under the TIFAC. And this has been the nodal agency in the country for facilitating the IPR related activities as a single facilitating windows. And thereby with this, the PIC, that is the Patent Information Center in all the states and union territories has been created and working in close coordination. And coming to the TIFAC, that is the Technology Information Forecasting and Assessment Council. This is an autonomous organization set up by the Department of Science and Technology to look into the technology domain, assess the technology trajectories, and support the innovation by networking kind of action in the selected areas of national importance. Yeah, thank you, sir, to be here with us today. And we have the next speaker, Dr. Shika Restoki. So she has her PhD in microbiology, and she has served as a patent examiner, and she has served as a patent attorney, and currently she is serving as a principal scientist in the innovation protection units of CSIR. So she has handled a lot of patent application for patentability assessment and drafting, and around 500 patent application she has guided under the prosecution in India and abroad. And we have another prominent speaker, Dr. Chitra. She has a doctorate degree in pharmacology. She is a patent attorney, and now she is a partner in Labs IP Care, Gurgaon. So she has been practicing in the field of IPR, that is the intellectual property rights, for about 2 decades now. And her expertise lies in identifying patentable subject matter, drafting, filing, and prosecution of the patent applications within the country and outside the country. So she has a wide experience in handling the techno-commercial and techno-legal facets of the intellectual property rights. And she has been a visiting professor at several academic institutions and deliver lectures and workshops. And I'm happy to say that Chitra, she's the first one who came to Nagaland to give the GI awareness through the department, I think we're back in 2015. And she's the one who has facilitated in filing the PIC also for filing the GI for Chakas and Shoals. And also she has represented the 3 tribal shoals, which was misappropriately filed by the outsider. So thank you, madam. And we have another prominent speaker, Siddhartha. He is a scientist from the Patent Information Center in Assam Science and Technology Council. And he is an IPR consultant for the Northeast region and a resource person for the state as well as the national level. So he has facilitated in patent filing, GI, trademark, and all, and for the state of Assam. And he is the one who gives a continuous support and hand-holding to the PIC Nagaland. And yeah, as we all know, that the India is celebrating its 75 years of independence. And our Honorable Prime Minister, he has a desire to infuse new energy and new consciousness among the people by showcasing and celebrating the achievement of the last 75 years through AZADI KA AMRIT MAHOTSAV. So in line with this, the Department of Science and Technology, Government of India, through the State S&T Councils and Patent Facilitating Center at TIFAC, is showcasing the STI, that is the Science, Technology and Innovation ecosystem in the state and union territories, and its contribution towards the Atmanirbhar Bharat through a year-long program of the celebration of the Science Festival under which is called Vidyan Utsav. So this Vidyan Utsav is celebrated to portray the state level STI ecosystem through month-wise themes. So the theme for this month, that is for August, is intellectual property rights, and this will be the today's talk. This will be the concluding activities for this science festival. Yeah. So as I said, that today's theme is on the intellectual property rights. Securing the intellectual property rights in the country, it's gaining its importance. So for securing the intellectual property rights have assumed utmost importance in order to achieve advantages in highly competitive innovation ecosystem and to sustain business having innovation potential. That is with reference to the product and the services. And with the advent of the World Trade Organization and India's obligation to meet the TRIPS requirement, Indian IP system has undergone the complete overhaul. So the today's talk, this will highlight the today's event. This will highlight the platform for providing insights to all the stakeholders about the IPR strength of the state for strengthening the innovation ecosystem for technological self-reliance, opportunity for students, potential startup, researcher, and industries to gain their knowledge about the IPR ecosystem in India, who potentially could avail the IPR services to protect their creativity through IPR in India as well as abroad, and the success story to trigger adopting the IPRs as integral part of their research, development, and business. Yeah, I wish you all the grand success for the program. So as I said earlier, we're having a DST meeting here at Bhopal. So I might not be able to join in between, but definitely I'll join in the discussion hour. So, and especially to the participants from Nagaland, I want to request you all to feel free and ask the question that clarify your doubts, as we have the expert from the country. And yeah, and to the speakers, today we have invited all the startup, the individual innovators, the researcher, the students. So today we have a combination of the expertise. Yeah, yeah, thank you.
That was Dr. Nessa Telle, Scientist D, looking after PIC, Nagaland Science and Technology Council. And now our first speaker, he will be highlighting about the IPR ecosystem in India by Dr. Yashwan Dev Panwar. Sir, you can take your time.
Yeah, good morning to all once again. And all my colleagues, which I'm very happy to see them. I will address them by first name, Dr. Chitra, Dr. Sikha, and Mr. Siddharth, Devanath. And Devanath and me share many common things, working in the area of IPR, plus in the name also. So if Nath is added to my Dev, so great to see you for this celebration of AZADI KA AMRIT MAHOTSAV. And as we are coming to completion of this 1-year celebration today, different aspects of science and technology ecosystem. And I'm glad that the whole month of August was actually dedicated to the theme IPR. And each one of our state took their approach to reach citizens of that particular residing in that particular state to take message of intellectual property to them. So a lot of efforts have been made in this month, and then there's actually a time for double celebration. And I think Dr. Nasatalu has already given an overview of IP system and the facilitation mechanism which is available. And I'm glad that so many people from different startup ecosystem, innovation ecosystem, academic ecosystem of Nagaland have joined this program of celebrating AZADI Ka Amrit Mahotsav with the theme of intellectual property rights. So any system which is functional have its own ecosystem. So there, the IP system also in our country, we have a intellectual property ecosystem. At different point of time, it was a different. So what I will do, I will share some of the slide and speak to you and appraise you about broadly the ecosystem exists in our country. And I'm sure the speakers of likes of Dr. Sikha, Dr. Chitra, and Devnath will be able to give a specific insight into IP and different forms of IP, and with a special reference to Northeast states, how IP is progressing, or how we are making a progress in the area of IP from that part of the country. So my role in today's celebration is to talk to you about the whole ecosystem in the country, which is to be utilized by all, including so when we talk about the ecosystem, so we really need to dissect and understand what all contribute to a vibrant ecosystem. So when we say IP ecosystem, it would not be in existence if we don't have intellectual property laws. So we have many IPR laws in place. We will just look at them, and then detailed deliberation will happen during the course of time. So first, we have to have IP laws, and how we have been amending them to meet our requirement of Indian creative community, as well as our global obligation under international arrangement, trade-related arrangements, agreements, etc. So the second most pillar of IP ecosystem is intellectual property offices. So to have and really administer different laws, receive application, process them, grant IP rights of a different nature, the role of IP offices are very, very important in really making the vibrant IP ecosystem in this country. And they have stood the scrutiny of time, and now actually progressing with a great stride, reducing time of a grant to the minimum possible in most of the cases. So when we say we have an IP law, we have IP offices, and we definitely need to reach out to people who are having potential intellectual property in their day-to-day work. They are coming up with new innovation, they're coming with new design, they are breeding plant varieties, They are coming up with the logos and the books, papers, research papers, softwares. But should they be spending their time in just understanding IP in detail, filing, prosecuting? So what these facilitation schemes support all these creators who are coming with the new innovative work, be it be inventions, be it be literary, artistic, cinematographic, designs, plant varieties, and whatnot. So we want them to focus on their technical work, and the facilitation agencies are supposed to take care of their need of protecting their intellectual property rights. So in India, we have so many facilitating agencies. One in Department of Science and Technology, this is called Patent Facilitation Program, under which the Patent Facilitating Center works at TIFAC, as well as about 26 states patent information centers are working, and one of them is at Nagaland State Science and Technology Council, where Dr. Nasatalu Hayes is handling the Patent Information Center and extending Department of Science and Technology's facilities to the citizens residing in the state of Nagaland and coming up with innovative work. So beside the TIFAC facilitation, there are other agencies we're going to discuss, including under Department of DPIIT, earlier used to be DIPP. So they have the whole organization in place called CPAM. They are doing awareness, facilitation, and other work under, and the patent office itself is running the SIPP scheme for facilitating, and other ministries and state governments and the state system. We have a lot of facilitation schemes which you can use remotely sitting in the state of Nagaland. And I firmly believe that if you reach to any one of them, you will be facilitated with protection of your intellectual property rights. And some of the schemes would really help you in taking forward your intellectual property rights for commercialization and monetization of your efforts which you put into creative work. So the IP laws, IP offices, and facilitation schemes plays a key role. So beside law, how we are going to handle intellectual property rights, how we're going to share the rights, who is going to be the owner of intellectual property rights, all those issues are not actually dealt by IP laws. So there is a need of IP policies, be it at a national level, where we have a national IPR policy 2016 in place. Many state governments have their IP policies, and at an institutional level, it is desired a policy document to handle intellectual property rights of the various institutions. And I think the private industries are governed by their IP policies, and India as well are free to use in a manner they want to use IP laws to their advantages. So the IP policy is also a very, very important part of IP ecosystem in India. Beside policies, you need experts who really can help you, in dealing and being a bridge between the IP system and you, to take you through IP offices, take you through facilitation schemes, and take you through different policies, and help you in making those documents ready and forward and submit at appropriate places with fees, etc., and to be able to teach you different aspects of intellectual property rights at a different time. So that's a very, very important component of an IP ecosystem. And these experts cannot be generated if we do not focus on IP education. So IP education and IP experts becomes an integral and important part of IP ecosystem in any country. And we have progressed phenomenally in this area of having number of IP expert, and most of the education institute now taking keen interest in teaching intellectual property rights. So may not be necessarily that everybody who get IP education become an IP expert, but they all get an insight. So I firmly believe that IP education to be imparted to all other students at a different level, and CBSE incorporated one of the chapter in the book at the 12th level to give them an insight about intellectual property rights. So when they deal different situation, different programs, different work culture in their life, they should be able to pinpoint their IP need in their day-to-day work, and then they can reach to right expert and help protecting the interest of their own, their employer or their factory, their company or their institute, and finally benefiting the whole country. So that's how I firmly believe that we need to put a lot of focus on it and make do content development for both experts in education and educationists, and the role of IPR attorneys, the patent agents, and the trademark agents who really help as an IP expert. Those are part of expert, but those are very specialized expert who has expertise in detail in handling day-to-day matters of the IP application drafting, be it the patent drafting or filing applications. And also these people have a network with international patent attorney and agents around the globe, through which they facilitate filing, obtaining intellectual property rights in other countries for Indian citizen and our people. So their role is very, very important. So I may miss some of important pillars of IP ecosystem and not going to finance and other issues, which are also very important. What kind of money we are putting into IP ecosystem. So that becomes a part of facilitation and other schemes. And broadly, what I feel, this is the ecosystem which is required for any country to progress in the area of intellectual property rights. So let's begin with laws. See, the IPs, I think the experts may talk to you in detail about different forms of intellectual property rights, but each of these forms need to have different kind of a protection. Like to protect our eyes from sun, we have sunglasses. To protect our feet from cracks on a roads, we need a shoes, and to absorb sweat, we need socks in the shoes. So different part on different type of any system need a different protection. So the same way, intellectual property protection system needs different kind of a laws, different kind of a protection mechanism for different kind of a creation. So in India, we recognize these patents, copyright, industrial design, trademarks, layout design, geographical indication, new plant variety as intellectual property, the independent intellectual property. There may be entanglement with one or other, but these are the recognized intellectual property rights form. Though we recognize trade secret as an intellectual property without having a specific law for trade secret, which is generally governed by other agreement called okay, so I have some very urgent call. I may take 2-3 minutes and I'll join you.
We have prominent resource persons today, so the participant can be ready with questions you may ask our resource persons here, so that we can all be benefited through this program. This is going to be our last celebrating online video sessions on Vigyan Utsav, AZADI Ka Amrit Mahotsav. So we can be ready with our questions. Thank you.
Yeah, sorry for the interruption.
No problem, sir.
Yeah, so that's something very urgent from. So these are different forms to handle these type of intellectual property rights. We have laws in place. So we have Patent Act 1970. Before that, we have a Patent Act. We had Patent Act 1911, which then 1970 we came up with other law. Then Design Act 2000. So these are the laws which are in place for us to really protect our intellectual property. So I'll share these slides, which can be shared with the participants. So you'll have all idea about what kind of laws we have in place in our country. So other important acts which have some kind of entanglement with intellectual property rights, Information Technology Act, IP and the Competition Law, Biodiversity Acts, and there are a few other laws which have some kind of entanglement with IPR. So we need to understand them appropriately while handling, but the expert will do. But if we want to protect our intellectual property rights outside, so Government of India has international treaties and agreement, like a multilateral, a part of India being a part of multilateral agreements like Paris Convention, Patent Cooperation Treaty, Budapest Treaty, Madrid, Marrakesh, and many other, to enable Indian creators of a knowledge to protect their intellectual property rights in different part of the globe. So these are the tools which are available, like PCT is filing international patent application, Budapest, and I think I'll not go into each of them one by one. So when we talk about patent office, so most of the IP offices are under the control of Controller General of Patent, Trademark and Design. be it the patent office, industrial design, trademark registration, GI registration, Chennai IP office, are also under the same control, and IC layout. Then there's a separate plant variety authority, which is not under the CGPTM, but now copyright office is also under the CGPTDM office. So it's all, now we have put all forms of intellectual property into one place other than new plant variety protection, which is a separate authority functioning in New Delhi. So this is the broad IPR ecosystem in our country. So these are the policies which we very important, even the science, technology and innovation policies, STI policy 2003, 2013, Government of India has entanglement of IPR, then a startup policy, and there are many other standard rural policy we may come up soon has entanglement with IPR. So we need to understand these policy issues with in reference to intellectual property rights in our country. So then we talk about agents and experts. So these are there are IPR cells in the universities, and TIFAC runs a very important scheme called Women Scientist Scheme, under which we train women who are away from science and technology for domestic reasons to come back and practice science and technology. And by taking 1 year training on intellectual property rights, especially patent searches, patent drafting, and patent analytics, etc. And they are about 700 to 800 women scientists have been trained under this scheme. So they get 1 year internship, 25,000 to 35,000 per month based on their qualification. And during this 1 year training, and after that, many of them are well placed. Then there are consultants or professors who teach intellectual property rights. So when we say network of IPR facilitating agencies as an IPR ecosystem, so we talked about TFC-PIC's network, and we also talked about National Research Development Corporation, who also facilitate IP protection as well as exploitation of intellectual property rights through helping them monetize their patents. Then for the grassroots innovators, there's an institute called National Innovation Foundation, which is in Ahmedabad, help grassroots innovators. And there's in the Ministry of MSME, there's a scheme called IP Facilitation Centers. Then for teaching IP and helping people getting patent document, there's a patent information system. Now this is Rajiv Gandhi Institute of Intellectual Property Rights and Management. Then there are internal IPR units. Dr. Sikha is there from CSIR, the DRDO, ICMR, DBT, DT, IITs, and many universities have their own IP cells. So this is of an IP office itself is also facilitating on various aspects to the applicants. So that's also a part of ecosystem of facilitation agencies. Then CI and FICCI and other organizations at the national level, which are facilitating IPR, makes a very important part of IP ecosystem. And then at international level, WIPO, GPO, EPO, and many other agencies are engaged in facilitating the transfer of knowledge, transfer of IP, protection of IP at an international level. So I think this makes a whole IPR ecosystem. So we have modernized our facility. We have made speedy disposal of cases, and even when it goes to court and IP jurisprudence, which I did not talk about in IP ecosystem, but that's a final and very important part of IP ecosystem. So our courts are giving faster decisions on the matters relating to intellectual property rights, makes IP ecosystem a very vibrant ecosystem. So I think this makes a whole IP ecosystem. I comes to an end of my time, and I may like to give what time I lost during my absence to add and eat into Dr. Sikha's time, maybe 2 to 3 minutes I can devote to the question and answer. So I stopped my share of slide here, and I hope I'm able to convey a broad idea or broad, able to present a broad framework which exists in our country as IPR ecosystem. So now over to you, over to the participants for the questions.
Thank you very much, sir, for the detailed presentation on pillars of IP, laws, office, facilitating schemes, policies, experts, education, IPR, attorney and agents. Thank you, sir. And I request, still have some few time, I request the participants to ask any question regarding the IPR ecosystem in India. If there is none now, you can have the discussion later also. And I believe our sir will still hold on to that. We'll go to the next presenter, that is on patent filing and its benefits by Dr. Shikha Rastogi, Principal Scientist, CSIR Innovation Protection Unit, New Delhi. Madam, you can take your time.
Thank you so much for the warm welcome. Wishing everybody a very, very happy and joyous occasion on the AZADI Ka Amrit Mahotsav. We are all in a celebration mode in our country. So in that stream, we'll from CSIR, we will be sharing the importance of IPRs, the topic which has been delegated to me for today's talk. I've tried to make it very, very concise so that I fit into the requirements, and the talk is open for questions at any moment of time. So I'll just share my screen for that purpose. Are the slides visible?
Yes, ma'am. It's clearly visible.
So the topic for today is the importance for of the IPR. So I've divided my talk into 5 different sections. I'd like to give an overview of the IP regime in the organization where I work, the importance of IPRs, their significance at the last, especially for the startups, and types of IPRs. I'll be focusing only a bit on the patents. So IPR regime in CSIR is as old as 1942, since the inception of CSIR. And because the mission CSIR is to provide scientific and industrial R&D that maximizes the economic, environmental, as well as societal benefits. So the aim of CSIR to generate IP is not only to gain economic advantage, but to alleviate the environmental problems and be useful to the society, Indian society by and large. The choices products from CSIR we can appreciate the indelible ink as early as 1960s. These all are protected by IPRs of different kinds. The indelible ink, why was the need of protecting this by IPR, and what was the need for developing such kind of an ink? We gained independence in 47, and after the constitution was enacted in India in 1950, we had to have a mark of democracy because we are a democratic organization. So we needed ink. So you can see the first invention that took place, it was by CSIR NPL. Then there was a need for the baby food, because at that time baby food was being produced mostly by the MNCs, and it was very difficult to adapt to Indian conditions because the multinational companies outside India, they relied on cow milk for the production of baby food, which is less in fat. To adapt that technology to produce baby food from buffalo milk, which is abundant in India, a lot of changes were to be done. So CSIR CFTRI developed Amul baby food, and this is still date in production. Then the revolution in agriculture by Swaraj tractors, pesticides in the late 1960s, supercomputers, and the spatial glasses. So we can appreciate as and when the country desired one or the other things, the mandate was given to CSIR to evolve with such technologies. Then after such basic technologies, we focused on the cash crops like the Kangra tea, the bamboo breakthrough of CSIR in the 1980s, the high menthol producing mint. Then came the catalysts, which is a very big portfolio which has been given to a big multinational giant. Then the DNA fingerprinting. the forensics, and there is a lab in Hyderabad which is known as CDFD. So the DNA fingerprinting technology was developed by CCMB. The leather technology at a point of time in the early 90s, the tannery industries were being directed to be shut down because they were causing enormous amount of pollution. It was difficult to manage the solid waste. The water was consisting of high TDS, color, and then chemical waste like chromium. So the one of the CSR labs in Chennai, that is CSR CLI, they focus, and we have a huge portfolio wherein now we have processes where we can produce leather with approximately zero waste. Then came the Haldi battle. It is a very well-known thing that in 1995, CSR challenged the US patent on turmeric, which was granted to a US firm. The then DG CSI, Dr. Mashelkar, when he read that news that US is granting a patent on turmeric, he, in collaboration with the Government of India through the Department of Science and Technology, and we initiated a suit for revocation of that US patent. And it sets an international trend to challenge the patents either in India or abroad based on the traditional knowledge of India. That also set a pace to develop a digital database wherein all the traditional knowledge of India can be documented. And that is how we started the TKDL. It started somewhere in 1995. This patent gave a ladder to it, and then with the intervention of the DATI, Ministry of Information Technology, and the Ministry of Science and Technology, a TKDL unit was set up, whose aim, now this unit is functioning under the aegis of CSIR. The aim of this unit is to translate all the traditional knowledge, be it in any language or form, into a digital database which can be accessed by different patent offices worldwide. On the similar lines, CSIR also won the Basmati patent battle, and it was also revoked. Then after these basic things, the need of the nation was quite different. Then we focused on the drugs. We should be proud to know that 11 of the 14 new drugs developed in independent India are from CSIR labs. These are protected by IPRs, by trademarks, and these includes a range including anesthetics, contraceptives, antimalarials, depressants, and memory enhancers. Two major drugs which CSIR can boast of is Centroman, that's Mary Saili, it's a once a week pill by CSIR CDRI, and the clot-specific streptokinase, which has been licensed to Nostrum Pharma USA, which has the highest ever licensing deal of $5 billion. Then CSR also worked in the area of light aviation aircraft, like the Hansa and Saras at CSR NAL. And then the drudgery of the Indian women while cooking was enormous with that stove, which had a pump in it. It was very difficult to light up that stove, and the women were it was really treacherous for some of them. So CSR IIP initiated, so you can just to give you an idea as to how the things evolved and how CSR responded to the needs of the nation. So this is an overview of the intellectual property base of CSIR. We have, as of date, filed around 12,000 patent applications since our inception in India, of which around 8,000, a few less than 8,000, you can say 7,800 cases have been granted. A similar number have been filed and granted abroad. So the portfolio includes both in-force patents, that means which are currently in force, and the patent applications which are pending, means they are still under prosecution either in India and abroad. This is the IP management policy of CSR, which is available on the IP website of CSR. Its basic points is to stimulate and encourage creativity, develop skills among the scientists through the techno-legal business information contained in the documents, use the information of the IP documents to mount strategic R&D programs, manage the IP portfolio as a business activity, manipulate defensively and aggressively for strategic and international S&T collaborations, mobilize national and international thinking on IP-related issues and concerns. The importance of IPRs, let's see why IPRs are important. Anybody who has an innovation or an idea if he doesn't secure the innovations by way of any of the intellectual property, can you just imagine, will it be able to reap any kind of revenue? No. If you have an invention, you do some research in the lab, publish a paper, or you write a blog or write a thesis or a book, anybody in the world, whosoever, is free to use that property because you don't have any rights on that intellect or that intellectual property. On the other hand, if you secure IPRs or IP for that innovation, you can license that, you can license the technology to a company or a startup or an MSME or whosoever you like, so that he may initiate the commercialization of that IP by way of technology transfer. This technology transfer leads to public use. Suppose you have made a device for harvesting wheat, which can harvest wheat in a very small time, and the agro waste which is generated can also be disposed of, degraded by the use of the device. It's an arbitrary device. So if you just publish it, nobody will be able to take a license for that, and it will never come into public use as such with a competition. But if you have an IP, a company takes a tech transfer for that, the public use is there is a revenue generation. So when you transfer a technology, you always have some guidelines for payment sharing, royalty sharing. So as and when the unit is sold, you get a revenue out of the sales. So that revenue is again pumped into the R&D cycle. So this is called the IP cycle. So to keep the cycle going, IP is essential. The benefits accrued by IP protection, some very trivial examples. Can you just imagine the multi-billion-dollar film recording publishing industry? Can it exist without a copyright protection? Or the rewards provided by the patent system, as we have seen, if I have developed a drug, a very nice drug to combat cardiovascular diseases or to combat stroke or to obviate the things like CNS breakdown. If I have developed a drug by investing huge amounts of money and 10 years of my precious time, and I just float that result or the drug molecule in the market, can I just reap any benefit out of it? No, and nobody will ever fund me further to do research. However, on the contrary, if I take an IP for that drug, what I can do is I can license the drug to a good company. That company can effectively market and produce a drug in the market, so that the revenues earned can be shared by the patent holder. That means if I have spent $100 billion to produce that drug in a period of 10 to 15 years, at least I get some money to pump again into my research cycle. Otherwise, I have no incentive to continue producing such good molecules. And without the trademark protection, do you have any reliability to buy a product confidently? The best example is like a smartphone. If you have 4 smartphones on a table and you don't have any label onto that, how would you decide which one to buy? As soon as the mark comes, Samsung, UI, Apple, Micromax, Redmi, then according to your confidence in that company, you will choose the desired phone. That is the fun of a trademark. And it's very important to know that if you have an IP evaluation in a company or a startup, the most important and valuable part is the trademark aspect. Like the Air India, the deal which Air India had, the maximum thing which carried monetary benefit was the trademark, not that the value of that Boeings or the jets which Air India has, or the fleet or the tangibles which Air India has on the ground, but the mark that has been sold to Tata. Intellectual property protection, these are the major 2 treaties. I've taken a very basic overview of the IPR. This is the Paris Convention. We have Paris Convention for protection of industrial property and Berne Convention for protection of literary and artistic works. All the treaties are administered by WIPO, which is the World Intellectual Property Organization, headquartered at Geneva. So let's see this only. I have taken only one slide to describe what are the intellectual property types, because the copyright is being taken by my other colleagues. So intellectual property refers to the creation of mind. It refers to patents, which is granted for inventions, trademarks, which represent symbols, names, images, etc. Industrial designs for objects like cars or your water bottles. Geographical indications of source like the Dharwad Pera, Darjeeling tea, Rockford cheese, champagne, layout designs of integrated circuits for IT related products and plant varieties. These 6 categories of IP are referred to as industrial property. Why? Because they can be made, use of, or they can be transferred to an industry for further purposes. However, copyright refers only to literary and artistic works and related rights to these works. So let's come to patents. I think I have 15 more minutes to go. The patent life cycle, if we see, it's a very simple life cycle. You have an invention, you prepare an invention disclosure, on the basis of which your attorney or your IP unit will prepare a patent application. You have to prepare that application, then file it with an appropriate IP office, wherever you desire to secure an IPR. For the Indian applicants, it is mandatory to file a patent application in India and proceed. And only then, after filing in India, we can proceed to file abroad. If we don't do it, we have a fine and imprisonment, either of them or both, under Section 39 of the Patents Act. So whenever you have a patent application, being an Indian applicant, you have to always file in India, and then you can decide if you want to file it in PCT, US, EP, JP, or any other jurisdiction outside India. That the patent application, wherever you file it, after filing it undergoes prosecution or examination by the patent office, respective patent office. For a single invention, if you have 5 patent applications filed in different countries, it will undergo examination at 5 times in different countries. After the patent is prosecuted and it is granted, after the grant, it's like any other property, like you have a house. So once you have a house registered in your name, what you do, every year you have to pay a property tax for that house or your commercial outlet to the government. So likewise for the patent, although it is intangible, but you have a property and you have to pay what is called the maintenance or the renewal fee to maintain it for a period of 20 years. So patent, what is a patent? Actually, how do we define a patent? A patent is a covenant between or an agreement between the government and the applicant, whereby in exchange of the inventor's complete disclosure, the government gives the inventor the right. So both ways they benefit. The government shields the inventor by not letting other copy his invention, and the inventor, how the government benefits, the inventor discloses his or her complete invention to the government so that the public can benefit at large. The property right provided in a patent is quite different from what we typically think of when we own a property. Like what is granted is not the right to make use. Government will not, if I manufacture patent a drug or a device for a CT scan, so the government will not ask me by giving a patent that you should make it, use it, or sell it. But the government will, on the other hand, stop others from making, using, offering for sale, selling, or importing the invention. That is why it's called a negative right. The purpose of a patent is to provide an advantage to the society as a whole by rewarding the development of new inventions. It promotes technological advancement by how? By stimulating research. So developing, innovating the drug is a risky and time-consuming and expensive process. Therefore, companies or organizations seek the protection of a patent to ensure that competitors will not immediately copy a product, and the investment which they have done can be reached in a stepwise manner. So reasons for patenting. Why? What is the importance of patenting? You have exclusive rights, you have an advantageous market position, high returns on investment, you have a licensing opportunity. If only if you have an IP, you can license it. Then if you have an IP, you can negotiate with the other companies. Suppose the case of MPEG-4 technology, it's not possible to run a smartphone without an MPEG-4 technology. But can every company should invent an MPEG-4? It's not possible. Even if they do it, the first person has the right by way of an IPR. So what the first person has done, he has secured rights on that MPEG technology, which is functional in so many smartphones and gadgets. And whosoever is desirous of using that technology in his or her gadget will take a license from that company. So the person who has the IP has the power of negotiating. For a corporate, it creates a positive corporate image, and it prevents others from taking advantage of your patented invention. So the international treaties on patents, the major ones are the Paris Convention for the Protection of Industrial Property, the Patent Cooperation Treaty, the Patent Law Treaty, Budapest Treaty, and Strasbourg Agreement. These 5 treaties particularly pertain to patents. Budapest Treaty is very important. It's for the recognition of the deposit of microorganisms for a patent purpose. If you are using a microorganism in an invention, then you cannot just have an IPR on that. First, you have to deposit that microorganism in an international recognized depository. Only then the patent office will grant a patent on that. So now we have seen the importance. So we should see what all can be patented. A process, for example, any process of enzymatic catalysis or isolation of a microbe or preparation of an extract from a plant. A composition of matter, for example, a drug or an enzyme, a machine, which can be an NMR machine, a spectrophotometer, CT scan, an article of manufacture like an electrophoretic apparatus or a water clarifier, and any new and useful improvement to either of these. So options to obtain a patent. How can we proceed to file a patent? The first one, as I told, should be the national route, wherein the patent applications are filed individually at the National Patent Office. For us, Indian nationals, the Indian Patent Office is our national patent office. Then we can have a regional route. Suppose I have a licensee in the European region. So Europe is a European Patent Office is a conglomerate of 37 European nations. If you want to take IPR's patent protection in that area, what you have to do is you have to file a unified patent application at the European Patent Office, which is called the EP regional route. The application is processed singly, and once it is prosecuted and granted, you have to validate in the countries in which you desire. It depends where your licensee is, where he is having his business. So you don't want to spend so much of money in validating it across all the countries of Europe. You can just choose at the time of validation. Then we have the PCT route, which is called the international route. Suppose I've developed a drug which can treat Alzheimer's. So it's a very wonderful drug. You can imagine the potential of that drug, that how important the drug is, and you want to protect that drug in many countries. It's not possible for a person to file similar applications in all the 153 countries at one go. So what we can do is, the PCT provides us a single window facility for patent protection, which is called the PCT application. And during the processing of the PCT application, we have a time of 30 months to decide in which countries we have an interest in seeking IP protection. The significance of IPR, this is just an example to make the talk interesting. Everybody in this talk must be having a smartphone. So in a single smartphone, you can see how many type of IPRs are there in a single smartphone. The technical solutions by patents, components, patents, manufacturing methods for the component, they have a patent. Camera, it is protected by patent. Lenses, the composition of the lenses, these or any other lens it has. The system for sending and receiving, its algorithm and something. Transmitters, new area of use. And the designs and other things are protected by the font, logo, display graphics. So a single smartphone can be has to be protected by so many IPRs, a bundle of IPRs. A Gillette razor, which people use in day-to-day life, can you imagine it has been protected by 53 different patents. So when you license that razor to a company, you have to license a bundle of 53 patents altogether. So this is what I've taken from a report from Dedrick and Kramer based on the IHS market teardown report of 2017. This is just an illustration to show you that in similar phones, out of the total, if the selling price of the good is $100 or 100 rupees, then 11 to 12% is the IP share. It's too much. And on that share, the licensors means one who has the technology and licenses. And licensee is he who receives the license. So the licensor, suppose you are the IP holder, so you are the licensor, so you can get a revenue out of the sales of these products. You can imagine the Coca-Cola can is the best example of a licensing deal. For the sale of each can of Coca-Cola, the person who has designed that can said, I want a royalty of 1 cent. 1 cent is nothing. But imagine the amount which he is earning in crores, millions of dollars every day. So IPRs are an essential tool for startups. For a company which is proactive in implementing IP solutions, it helps them to identify novel innovations and increase their revenues. A well-defined IP goal achieves business objectives and makes you a leader in the marketplace. It helps your growth in business revenues and explore new geographies. If you have IP in different countries, so you can have your startup established in different countries. Licensing or joint ventures. You have a very good IP, a very small one although, but you know that it is critical for the functioning of a desktop. So you can imagine the joint venture you can have with companies like Dell, HP, Lenovo, and other companies which are manufacturing desktops, because that technology which you have developed may be essential to function a new kind of a desktop. An organization's patent portfolio is vital for its future success along its various IP assets such as designs, trademarks, and copyrights. This is just a demographic detail. So startups or MSCs with registered IPRs are more likely to receive funding. A study reveals that SMEs and startups which have at least one registered IP are 21% more likely to experience a subsequent growth period and 10% more likely to become a high growth firm. This is just a depiction. This image is taken from a WIPO report, which has said that this is the era of startups, and see in different sectors like healthcare, manufacturing, supply chain, retail, energy, natural resources, and banking, financial, and insurance sector. See the amount of startups which are there. So the maximum startups are in the BFSI, followed by healthcare. Manufacturing and supply chain are almost similar with retail, but energy sector has no startups. So you can also map your domain of working by such kind of analysis. So this is the presence of startups in different geographies. India is somewhere in between, the maximum being in US, followed by China for robotics, not for any other. But US, you have a majority of startups in all fields. Next step. So in the Indian Patents Act and rules, we have revised provisions of startups since 2017. So a startup means an entity in India recognized as a startup by the competent authority, means the government, under Startup India initiative. And in case of a foreign entity, an entity fulfilling the criteria of turnover and period of incorporation as per the Startup India initiative and submitting of a declaration to that effect. So the facility of expedited examination has been provided to startups. What does that mean? Since 2019, it has been provided. It means that if you are in startup, then you don't have to wait for a period of 4 years to get a patent application examined. You can immediately file a request for expedited examination. So the patent fees for startup has also been drastically reduced and made similar to that of a natural person or a small entity. For filing a new patent application for organizations like CSR, we have to spend 8,000 rupees. But for startups, it is only 1,600. That is a slash term of 80%. Likewise, the request for examination fees for CSR is 20,000. But for startups, it's very less. So initiatives for Startup India program by the government are substantial fee reduction, 80% fee concession for patent applications, 50% for trademarks also. The Department for Promotion of Industry and Industrial Trade under the Ministry of Industry and Commerce, they have, for the launch of the SIPP, they have the facilitating startups, wherein at the website of the Indian Patent Office, you have a list of patent facilitators who are there, appointed by the Indian Patent Office to help the startups in drafting, filing, and prosecuting their patent applications. So this is the statistics taken from the Indian Patent Office annual report 1920. Applications filed by startups is 1652 out of the total 56,000. But if you can see, the numbers are gradually increasing. In 2016, the number was very low, 160. But in 1920, it's almost 10 times. So for the universities also, the Indian Patent Office has made some amendments by the way of Patent Amendment Rules 2021. So the university has been included under the amendment of Rule 2CA, wherein it has been included under the ambit of educational institution. And likewise for the startup, the patent fees for universities also has been included. Suppose you are a university in Nagaland and you want to file a patent for application for a patent. So now you don't have to shell out 8,000 rupees, only 1,600 rupees for filing a new application and 4,000 for filing the request for examination. That's all. And I'll welcome any questions, if any.
Thank you, madam. And any participants can ask any questions. But I think the time is for the next session, and we will go for the socio-economic impact and benefits of GI.
Yeah.
Okay, thank you, ma'am. By Dr. Chitra Arvind, IP attorney, partner. Ma'am, you can take your time.
Socio-economic impact of benefits of geographical indicators of Government of India. Chitra Arvind. Okay, I put this in.
A very warm good afternoon to all of you. A very warm welcome and thanks for having me in this session. A very good afternoon to friends and family from Nagaland. I mentioned the word families even though I'm from South because I have been to Nagaland twice and all of you have opened your hearts and home to me, to my family, my 6-year-old daughter there. So when I give this lecture and I think about this AZADI KA AMRIT MAHOTSAV, I only see the connect that we have amongst ourselves as friends, as colleagues, and as family. So I really want, my friends and family in Nagaland to be benefited by the intellectual property rights and the various things that we have as India to have, and file geographical indications because Nagaland is very rich in geographical indications and benefit out of it. So let's see what are the benefits that we are going to have both in terms of social and in terms of, economic benefits. How many of these products all of us recognize? Probably all of them. Darjeeling tea, coffee from Colombia, Rasagulla, Switzerland cheese, the cheese with a hole, basmati rice, champagne, which we open every time that there's going to be a celebration. All of this we associate with the place of origin. It is similar when we say blue cheese, when we say Darjeeling tea, when we say cognac, Scotch, Porto, Havana, tequila. Every single thing, when we say this name, we know from which area it comes from. So that is geographical indications. And geographical indication is the name which is associated to a good, which identifies a product of a certain nature, and it is known for its geographical origin. And the characteristics of the product are always associated with the source. Now let us see what is the definition of a geographical indication which is given in the Act. So any goods which originates from a place and or manufactured in the territory of a country, a region, or a locality in the region, and when this good is associated with quality, reputation to that particular geographical origin, we'll have to go and apply for a geographical origin. If you see our Chakisang socks from Nagaland, Thai silk, bastar, all these are handicrafts and which can be associated with this particular region, and they get protected under geographical indication. It is true for our agricultural products also, including our Naga mircha, Naga tree tomato, Naga cucumber, and many other things. It's also possible for us to protect foodstuff like Roquefort cheese and everything which can be identified with the place of origin. It is similar for alcohol and alcoholic beverages like Scotch whisky and everything. So summarizing, any goods which originate from a region and the name of the goods can be associated with a region, it becomes a geographical indication. But why should we protect geographical indication? How about our traditional knowledge? At one point of time, we all had joint families with our grandmothers and grandfathers and our parents and children and everybody sitting together. And every day our grandparents used to tell us about what it is and what is our culture and heritage. But such societies are diminishing. How do you transmit the knowledge of our ancestors to our children? So when you file a geographical origin, you make a story, and if not through oral, we document it as this is our tradition. It preserves the skill of the community. I have been around Nagaland and I see that, people are weaving and, they are taking a fiber from the thistle and they are breaking that fiber and making it into wonderful shawls. How do you transmit that knowledge and how do you preserve the skills of the old ladies and pass it on to our younger generation, to our girls? This shawl takes months for people to prepare. When you have months to prepare a shawl and you want to sell that shawl, should it not help it to bring in money and give sustenance to that particular person who has spent months in making that shawl? Otherwise, why would that person choose it as a profession or choose to continue doing it? It becomes a livelihood for that person. I have seen welfare societies. I have seen people associated with churches. And how do you bring in money for these people who want to spend their time preserving their culture and making shawls? It becomes, a matter of livelihood. How do you prevent biopiracy? There has to be, like Mr. Yeshwant said, a framework around it. You have to know what to protect, how to protect, and that is how you prevent biopiracy. Any geographical indication has a lot of support, and that has to boost the export of that particular product. And when a product is exported, certainly the price range becomes different. And there has to be a sustainable development and a sustainable preservation of knowledge. Without this, it is quite difficult for us to preserve our knowledge, our community. The major difference between geographical indication and other type of IP is that a geographical indication is for a community and not for any individuals. Individual means either, company or an individual person. But GI is not so. GI is for the community. So how does a GI happen? First, you file an application. this file application, you have to talk about the heritage. You have to talk about as to how the knowledge for which you are claiming a GI is associated with one particular place. Okay, and what is the history? We have to go, if it is oral, we have to document it. And this is the manner of preserving. And we have to tell people as to how this knowledge is associated with a community or is associated with a place, or how the characteristics are attributable to the place of the origin. It can be a shawl, it can be an agricultural. But this application will go for a formal and a technical examination. Once it is done, it is entered and it's advertised. People can oppose it at this particular point of time. If there is no opposition or people are able to overcome the opposition, the applicant is able to overcome the opposition by any other third party, it gets registered. After rectification also, if some person has any grievance, they can file a rectification petition saying that no, whatever reason may be. Then it becomes a registered GI. But see, a registered GI is held by one person. But many people of that community cannot be excluded, or the intention of GI is not to exclude other people other than registered users. People who are all associated with that particular community, but who want to be associated with that particular product can become authorized users. But as any way, when there is an authorized user, there has to be rules and regulations as to how people produce and market the product without diluting or without hurting the sentiments of the GI per se. So who is an authorized user? Any person who produces, makes, manufactures, trades, packages, or deals with the registered user of GI can apply to become an authorized user. Okay, so we cannot exclude other people and everybody can be a part of it because it's a cognizance of the people involved. But if the registered user can effectively manage the authorized user, then the quality of the GI and the knowledge is preserved intact and does not become diluted in any particular manner. So you have a GI owner. In other manner, the GI owner is known as the registered user. Under the registered user, there can be other authorized users, and under one authorized user, there can be few other authorized users. But if you have an apex body or if there is a pyramidal structure, it becomes very easy for us to ensure that our GI is able to achieve a good reputation and a marketing status. So what is the path that you will walk in a GI? If you don't have a GI, what will happen? Nobody will understand the value of the product or the value of the knowledge which is associated with that particular GI. The product can be adulterated, or the knowledge, like in terms of, how to make a shawl, who is to wear the shawl, will all get diluted. And there will be consumer deception. And there is also damage to reputation and sensitization, lack of sensitization as to what this GI is in the rest of the places. So what do you do when you get a GI? When you get a GI, you get a statutory backup, which prevents misuse, abuse, and if anybody else is going into your GI, you can always sue for infringements. If the GI is administered correctly between the old and the authorized users, there becomes a supply chain integrity. And always it is possible for you to have a specialty logo which you can place on the GI and which becomes a source of identification. So what happens in this process of accumulation of knowledge and filing of a GI? Your product protected under GI becomes a brand. So it is conversion of a source of a product to a brand. Now you would ask me, well, do not brands get protected under trademarks? Yes, brands get protected on trademarks. Trademarks and GI are not the same, but it is possible for them to coexist in a different manner, and every time a GI will take precedence over trademark. But it is possible for us to do both so as to effectively protect your product. In a trademark, you can do a design, a symbol, a sign, and a word which can be affixed on the product to trace the origin. But a GI is only a word, and this word has to help the people to identify the origin. A trademark covers both goods and services, but a GI is only mostly on goods. Generally, a trademark is owned by that legal entity, but a GI is always a collective knowledge. A GI can never be held by an independent entity. It can be held by the registered user and used by the registered user to identify the source and the origin. So there are different kinds of trademarks. How will you use these trademarks? In combination with GI. So if it is an individual mark, it's just a mark which helps us to identify the product from that particular legal entity. But we can have a collective mark. Mostly the GI marks are a collective mark which can be used by the registered user of GI and also the authorized users who fall under the registered users. Then you will also have a certification mark which gives the quality and the nature of the products. Let us look at some of the individual marks like a Coca-Cola. You know who is the owner of Coca-Cola and you will have an individual trademark for this. I'm sure all of you will identify the typical logo for Darjeeling mark. Okay, so when this gets affixed on your tea, you know that this is Darjeeling. Okay, this is Darjeeling tea. This is authentic. Okay, and I know if I have this mark, I do get only Darjeeling tea. This is a wool mark. Wool mark is a certification mark. For example, even your ISI mark is a certification mark, which certifies as to what is the quality of the product. If your collective mark is so good that it acquires the flavor of a certification mark, and people who get this particular product will be assured of the source and of the quality. So as a GI, we have to ensure that we have a combination of both, and this particular combination, whatever is available, this combination needs to be done in a very nice and a collective manner. As I said, a GI is very important, especially in terms of collective knowledge to bring in the socio-economic advantages that we have. We need to protect and preserve our traditional knowledge. What better manner is it to do and collate all data under GI, including the history? If we don't file for GI, I'm sure, we may not make efforts to collate and document this knowledge. So for me, this is first. Otherwise, as we lose generations, we are going to lose the rich knowledge which is associated with a region, and therefore this must be encouraged. It's a public interest. Okay, you do go to some shops, local shops across India, you're going to get products which are going to say they are Naga shawls, but they are not. Okay, but how do you ensure that? You have to ensure that you source and trace your supply chain. How about the empowerment of women? Most of these geographical indications, especially in terms of handicrafts, are handled by women. How do we ensure that we empower them? How do we ensure that we give them, enough source of income for that particular country or that particular region or that particular community? This is a way of doing it by enriching our people to know about GI, disperse the knowledge about GI, and ensure that they get benefited economically by them. As of now, most of them are home sectors. How do you make the home sectors into a fledgling industry at least and convert that small fledgling industry to a multi-billion-dollar business? Organization of the sector. Think of Amul. Think of how, all the cows which were there and how the milk was collated. And what is Amul today? It is an organization of the domestic sector. How will you disperse funds to the society at large? There needs to be an apex entity. Look at the people who are associated with Amul today and where they give milk to Amul today. Look at their status, economic status as to how it has grown from a small domestic household to a, middle income and senior income domestic household. So, and not only this, do we not want to tell our tradition across the globe? We need to. And that is why you need to go for a GI. Why is this discussion so important? I repeat, geographical indication is by the people, for the people. I'm not reading out, the words of Kennedy, but we must attempt to bring back people to community. As Mahatma Gandhi said, our lives lives in villages and our knowledge lives in villages. So in the 75th independence anniversary, I request that we all reach out to our community and start collating this knowledge and protect it by way of GI. Look at the economic benefits. It's not only social, it's also economic. Let's look at champagne. Before GI, it was $12. It's $40 after a GI has been acquired. Look at Antigua coffee beans. 0.5 came to 1.5. That's a 200% growth. This is true for Jamal coffee also. Unfortunately, in India, the price rise between, before and after GI is not highly documented, and I've not been able to get a lot of data on this. But what I was being able to get is Darjeeling. You see, the source of Darjeeling is so well controlled that when the production of Darjeeling falls inside India, the prices of Darjeeling tea is raised across the globe. Just shows how tight the supply chain is. At one point, 90 kg of Darjeeling tea in India fetched around 40 lakhs. In UK, which is about 45,000 rupees per kg. Imagine, are we drinking tea for 45,000 rupees per kg? Look at the source control of Darjeeling. Look at the price control of Darjeeling. Okay? How? Because they track it, they place their logo, they ensure that there is a supply chain control. Some of the newly formed GIs are also started doing this very carefully, and they ensure that the GI registration and the products are available only at certain unique stores. I would like to pick the Rasagulla and Rasagullar. One is by Odisha and one is by Bengal. For this to see how you can see, they say that in the shop a GI-based Rasagulla is available. See it in Calcutta. It's a newly formed GI. Okay, but however, in many other places, people are unable to benefit from as to the GI that they have already obtained. I want to show a picture. Some people do have a GI, but look at the artisan. But India has several GI stores where the authenticity is available, and this is a premium price. Where do we want our people to be? This is a call that we take as a community. I want to, talk about Darjeeling as to how they manage their GI and trademark, one of the best managed, spread over so many thousands of hectares. They make a lot of tea. They have 87 tea estates, lakhs of workers, predominantly women, and main economic activity of the area, and they have exported a lot. If you see the literature, it recognized Darjeeling tea from 1830s. Okay, a tea in 1930s and 53s, they have made, laws, and it culminated in the Tea Act. In 60s to 80s, they have made a tea board with all authority. They were able to control all production. They were the first people when, India had accession to TRIPS. They were the first people to recognize GI, and Darjeeling tea is filed as GI number 1 and 2. All Darjeeling cultivators are authorized users. Not only that, they went starting from 2007, they sued people misusing Darjeeling, including the Darjeeling perfume in France. Somebody had misused. Okay, they went across and sued everybody across the globe. Whatever money they got, it was held by this apex body, tea board. They went and sued for, misuse of the mark, dilution of the mark, enforced the mark across the globe. There were perfumes by the name of Darjeeling in France. They went and stopped them. They did this across, globe. So now everybody is scared to use the word Darjeeling. So the GI Darjeeling tea has now transposed into the brand Darjeeling. And anybody who sees the tea pick logo, they know what it is. What is happening to our own Naga GIs? I've checked the records. We have a Naga Mircha, we have a Naga tomato. Okay, there are a few authorized users for Naga Mircha and Naga tomato. We have a few authorized users for Chekisang shovels. But have we converted our GI product into brands yet? We need to think about this and start converting our brands, our GI names to brands, and ensure that, there is a lot of income which is generated from it. There is a difference. If you see in GI covers only certain classes. These classes are associated with certain brands, certain goods. So if you have classes 1 to 35, which is common to trademark and GI, you have different goods, and each class will follow one good each. So you have to file across the good. Say, for example, this is, whiskey, so you will cover it in alcoholic beverages. Or if it is handicrafts, you will cover it in the handicraft classes. If it's food, you will cover it in the classes. The services are not covered in GI. But like in case of Darjeeling, when Darjeeling was fighting, there was a Darjeeling Lounge, which is a service because there they serve tea. But you have to build a reputation in such a manner that this reputation is carried across goods and services. There are a lot of international brands such like Scotch who have taken advantage of this provision in the Act to ensure that both services are covered across the GI, and they are able to enforce everybody across. Are we doing it? Look at the state, Darjeeling is a very nice example. Look at the state of some other GIs. We have full curry. Okay, the full curry doesn't cover a lot of things. We have now full curry in cushion covers, pillow covers, shoes. Okay, how are we able to stop them? Look at Worli paintings. Okay, talking about few paintings in GI. It's there in cloth, it's there in nail art in beauty parlors. How are we able to stop them? Okay, so there lies the power of enforcement. Unfortunately, procuring a GI is the first step. The GI has to be gone to an authorized user, and there has to be a registration, there has to be a management, it has to be a whole marketing platform and a technology. Okay, so this is the power of enforcement. When you enforce, you build your reputation for the name across the border, then the people or the end users, the person who buy, are assured of authenticity. There is a brand image which is built around it, and people will be ready to pay a premium for these products. So we need to build this for all of them. What happened? As I said, Naga cucumber shows abandoned. Okay, there are many other Naga products which we started for GI. Okay, but how fast are we on them? What happened to already registered GIs of Nagaland? How many authorized users are there? How is the supply chain being controlled? What are the marketing steps? Do we have in Kohima and in Dimapur GI stores? What is the income generated? Are we ensuring that our products are available in other GI stores? Have we made a story for every Naga shawl? I know Hapidasa shawl of, Chakisang is only given to kings and other people, but how would other people know? We have to translate this, okay, into marketing strategy. And that's how, we create our GI and transform it into brands, make it from small scale industries to large scale industries, and ensure that an income is generated, which goes back to our own people, so that the quality of lives our people are improved drastically. Okay, I want to conclude in the words of Mother Teresa. I alone cannot change the world, but I can cast a stone across the waters to create many ripples. It's not possible for me or you, but I'm sure students, friends, families of many people from Nagaland are looking and hearing to this. Each one of us has to think like Mother Teresa and start creating ripples. The ripples should become a stream to a torrent. And all of us need to be benefited by this particular IPR. Thank you.
Thank you, Madam, for sharing on socioeconomic impact and benefits of GI. And in particular, we want to thank you for considering us and making us your family. Thank you very much. Later, I think we have more discussion on, have more discussion and questions on this particular GI topic. We'll go to our next speaker on copyright and trademark and its benefit by Mr. Siddhartho Devnath, Scientist C, PIC Aztec, Guwahati. Sir, you can take your time.
Thank you so much. And I thank Dr. Chitra Madam for a wonderful presentation, and also Dr. Shikha Ma'am and Dr. Panwar Sir, because the insights of these experts make this whole celebration today very vibrant. I thank Nagaland State and Technology Council, NASTEC, for having me as a resource person. I hope I can share something from my experience. I have been in the IP field for almost 12 years now, and going for a further journey. And hope I can contribute something to today's this Vigyan Utsav. The topic given to me is copyright and trademark and their benefits. So it's almost half an hour program on my side. So I'll try to be very brief. And if there is any question, dear participants, you may also put it in the chat box. I'll try to answer later on, or maybe during the program also. No problem. So let's go to copyright and trademark and their benefits. Copyright we can define as a grant of exclusive rights to the original work of an author given for a certain period of time by the government to make copies of the same and prevent its unauthorized use by others. Copyright leads to something which is known as a right which is given by the government to actually make copies of your work. So the grant is such that there are some exclusive rights which the government gives to the creator and the original owner of that copyrightable work so that he and she could actually make copies authentically. And at the same time, those rights also protect anyone who wants to do some illegal activities like copying those works without proper permission. Hence, we can say a copyright is something a very unique type of right in the whole IPR regime, which actually boosts and urges you to make copies through a proper permission channel. The copyright word actually it is made up of two bywords. One is copy and one is right. So you have a right to copy. Everything that we do in our day-to-day lives results in some kind of a copy, isn't it? As you can see, I put a picture of a photocopier machine, and photocopier machine is used in our office, day-to-day lives, everywhere. So every time a copy is made in the photocopier machine, copyright is triggered. If you're going to say take a photocopy of your driving license, you are giving the driving license to the operator. He or she is doing a photocopy and you get the copy to yourself in the paper form. When you submit it to agency who needs your say an ID proof, then copyright is still intact because that information you have provided, that the copy of your driving license, that should not be used or not be further copied by anyone without your permission. Copyright mainly comes usually in case of a literary work, and it also started long time ago. There is not concrete evidence, but we say the Chinese built printing presses where we copy different type of work, and earlier there were some stone carvings. So the kings and the rulers, they had to carve on the stones, and then if you want to make a copy, then you can carve it again. So they made some technologies in which we can put some ink and make some copies. So this is how the copyright came. But the problem was that once you make a raw technology by which you can make copies, then what happens to the original creator in case of some original work? That is how this copyright actually came into existence, so that the government will protect the owner, the author, as we call it in here, that his or her work is not copied illegally, and he can use or she can use her work for making copies. The basic symbology that we use in copyright is that C under a circle, and the pattern is like first we use the symbol, then we use the year, and then we use the owner of that copyright. Example, where copyright, for example, this is the program agenda. This agenda has been received from NASDAQ. Okay, but if we go to the law, if we go to the court today, someone challenges it. Who owns the copyright in this? Okay, now this is being emailed to me. Now, if I distribute it to everyone here and I take some money out of it, I'm doing some commercial activity, then yes, in that case, NASDAQ can stop me, because since I've received it from NASDAQ, it is made by NASDAQ. So this program schedule is also owned by NASDAQ. But what about the other cases? What about the Ashok Stamp? What about the logo? What about who owns them? Accordingly, they are also owned by different kind of parties. But here, since we are not doing any commercial activity, we can freely use such papers if you are used for education, research, or purposes like that we are doing celebrating a big anniversary. The basic criteria for a copyright is that the work has involved some labor. In making this presentation, presentation of this information, some labor has been involved, right? There has been some discussion, there have been some meetings, who will be the resource persons, what will be the time, that is labor. Second is the skill. Skill, what is the arrangement? what will be the time, who will talk about which, and how to arrange the people together so that that will be a good program. That is the skill and originality. This arrangement of the agenda has not been copied from any other state councils previous. Then we call that this is a originality, and thus we can say that this may be a copyrightable. Now, copyright in India is governed by the Copyright Act 1970 and also its rules 2003. I'll just give an example of, for example, you have this book. What is the copyright thing? Copyright means the text of the book, the thought. Actually, here, if you say copyright is just making copies of the book, that is in the printing press. If you scan it in the PDF, that is also a copy. If you make photocopies, that is also a copy. And here in books, you can see who is a writer here. IP book, Narayanan sir is a very famous writer. So there you can see here the copyright is given not to the author but to Eastern Law House Private Limited, which is like a publishing company. Thus, we can say that copyright is not only rests with the owner, it also rests with the publishing company, because the publishing company has to make copies, but with the prior permission of the. What is the subject matter of copyright? In copyright, we use various kinds of classes of work that we come upon. The first is the literary work. Literary work means anything that is written in some kind of a script on a piece of paper, that is a literary and has got some kind of a meaning. That is the most important. In any language, in any script you write something, just put in a piece of paper, that may be subject matter of copyright. Literary also covers translations. If you want to translate an English to say Nagamese, that is also a subject matter of copyright. If you want to write a gist or an abstract of a big article, that is also a subject matter of copyright. Head notes in case of a court proceedings. If you're compiling, say I can say the annual report of your council. If you're then even setting up question papers, if you're writing something in Facebook, whatever you're writing, it is literary. Thus, it is a subject matter of copyright as long as it satisfies the criteria of the copyright. Next, we can go for artistic work. Artistic work involves anything that relates to art, such as a painting, a sculpture, the tallest sculpture you can say in India. So what do you say? Someone has to own the copyright over it. Someone has made it. It is not that it is made by hand. It may be made by some kind of machines too. But a sculpture is made, so someone has to own the copyright in it, because you cannot make this much small replica of the whole, the tallest structure, and then you sell it on the market without permission. Yes, that is something comes under copyright. But in India, we know we are very lenient. We can buy Taj Mahal replicas and other replicas, but that actually comes under the ambit of the copyright, because those are artistic works. If you go to musical works especially have got three subclasses. The first is the lyrics. Lyrics will come to the literary work. So here there is also vocals. Where in the vocals? So vocals will go to a different thing, that is sound record. So if we can analyze all those things together, you can say and come to one conclusion that a song itself does not have a copyright. So why I'm telling about this musical? Musical refers to the musical notations that we have, such as a piano notations, drum notations, guitar notations, vocal notations that we write. That is the in a sheet of paper. Now that cannot be considered as a literary work, because it does not have got scripts of a language, but it is a musical language. So we have a specific class of subject matter of that copyright, which is called as a musical work. And this is mainly done by the composers. If you are in a band, you are composing new songs, then you might be thinking that if I copyright the song, put it in, let's write copyright, it may not even be protected. No. If you are making the new tune, which is very new and original, then that tune has to be written in the form of a musical notations with all the instruments together, maybe 1 page, 2 page, 100 pages, doesn't matter. And then you have to get a copyright, and that will be your musical copyright. After that, if someone steals that, your copies your music, put it into some videos and something, then what will happen in the court? You have to prove that this copyright is being copied. Then you have to show that yes, this is my copyright over all the notations. You can decode the notations from the other party, and thus this is how you can proceed with a musical notation. Next is a computer program. As you can see on the bottom left, I have a small screenshot of a computer program. It's Pascal, C, C++. What are those? Those are just some text, but has got meaning in a computer language. Similarly, they are also considered as a literary work, but special class is of a computer program. And in that case, we can say a computer program, how do you copyright it? Just you cannot send the program to the copyright office, right? You have to first print out, or you have to put all the whole program into some kind of a form, such as paper or a DVD or a CD, and then you have to compile the computer program, and then you will come to a object code. That is what the intermediate code, the compiler of a computer program does. That has got some codes, machine language code. That also you have to print out or put it into a CD. Then you have to send it to copyright office to register. Now, when the copyright office registers, it looks into what is the source code, that is your computer program, and what is the object code, that is the machine language, the output. And then only it runs the copyright. Then if this software, this computer program is being copied by someone else, when you go to the code, you have to show that this is my code. And if this is compiled, this object code is formed. If similar object code is formed from that infringing computer program, then that could be a matter of infringement to be proved. We also have copyright in cinematograph films, that is movies. Here, cinematograph film means a running set of pictures with a frame rate and also an audio together. Remember, audio together. And finally, we have sound record. Sound recordings is just the recordings of the audio that you have, and we can actually send it to copyright office for recording. Audio could be voice and also some kinds of music. So here, all the pictures, like if you're watching a YouTube videos, then there will be copyright in the video itself. You cannot download and share it. There will be a copyright in the audio. There will be copyright in the images appearing in the video, or the something other. If a paper appears constant some text, that is also a subject matter of copyright. Hence, you can see if you're creating a video, you have to be very careful that those things that are shown in the video should not have a copyright earlier, or if there is something, you have to take a proper permission from the author. At the bottom, you can see there is a concert going on. So these are also subject matter of copyright, which we call as performer's rights. If someone is performing on a stage, that performer has a copyright, and it prevents the audience from recording that session and sharing and using for commercial activity. So it is illegal to record a performance in a show. Yes, as per copyright. After the subject matter of copyright, let's go to the registration part. How can we register copyright? We have to first compile your work together. That is, if it's a literary work, you have to make a copy of your book. You have to print out the book. That is the book. Then, if you want to register it, you have to fill up a form 14, where it tells who is the author, what is the title, then what are your addresses, and are there any other authors where you have is it translation or not, any other authors who will have rights. If two people are writing this book, then one people cannot file the copyright. They have to file it by themselves, or one has to assign the rights. All those things will come in the form 14. After that, we have statement of particulars, which will tell all the details about this copywriting. And then later we come to statement of further particulars. If it's a translation, adaptation, and fees. Fees will be minimum 500 rupees for a literary work, and it goes up to 5,000 rupees for a cinematograph film, 2,000 rupees for an sound recording. After that, the application, when you are ready with having all those things together, you file it to the Copyright Office, and you have to send 2 copies of your work. If it's a book, send 2 copies, and then the Copyright Office will put your application for a mandatory waiting period of 30 days, that is 1 month. After that, it will be examined whether anything is there or not, which is objectionable, if someone has objected to it, or any such matters. After that, if everything is okay, then the Copyright Office will give you a grant of the copyright to this book by sending and issuing a certificate of registration, and along with the certificate, they will send 1 copy of that book. You have sent 2 copies, 1 copy they will send you back. Thus, this is the proof of your copyright registration. Tomorrow, if you have any other infringement case, you have to go to the court. You just have to take this copy given by the Copyright Office and the certificate to prove that this belongs to you. The term of a copyright is very, very high in comparison to any other IPRs. Once you register any other IPRs, you get for a limited time, you get a validity of the registration. But in case of copyright, for any kind of a published literary, dramatic, musical, or even artistic work, it exists for the lifetime of the author and another 60 years. Even if the author dies, his descendants, his legal representatives can even enjoy the copyright for another 60 years. So I think you may have some, sometimes we watch some movies where you can see the kids, they don't do anything, but they have got the royalty from the copyright from their parents. So that is true. Not only it also exists in case of a big publishing agencies. And in case of photographs, then movies, sound recording, it is 60 years from publication. Publication date is taken after the date when it is actually published or disclosed. Now, interestingly, here 60 years of movies. So those movies we have crossed 60 years, you can actually copy them and use them. There are no other problems. But inside the movies, if there are any literary work, dramatic work, musical work, music, and also artistic work in that movie, they will have copyright for another 60 years, mind you. So you actually cannot directly download and use it for commercial sale. You have to check all the movies that it is devoid of any other copyrights. And the other like performance and broadcasting rights, which have got about 25 years of validity. Interestingly, both published and unpublished work are entitled for copyright. So if this book, I publish it today, and after 2 years, I can also apply for its copyright registration, or I can apply fresh before it's published. The benefits of copyright is due to the different statutory rights that the copyright provides. So once you're registered, you get a copyright in a book. Say, for example, you get a right to reproduce it in any material form. That is, you can make a PDF, you can scan and make a PDF, and you can distribute it or sell it. That is one right. If you read this book, you can make a movie out of this book. That is also allowed in case of a copyright. But others, they cannot do it because there is a right which is called right against infringement, which prevents any other person other than you to do any of those things. Now, copying a part or a whole is also considered under copyright. And if you want to translate the book, and interestingly, copyright rights, the statutory rights also involve the right to sell, no problem. Also offering to sell. If I put an advertisement in, say, Amazon or Flipkart that I have got this book, so that also right is been protected by the Copyright Act. Then there are other rights like right to transfer. We can transfer the different rights, and also moral rights such as integrity right and paternity right, where if you even assign all the rights to the publisher cannot change the contents inside. So those are some other rights. So the benefits of copyright is that once you register a copyright, you get the exclusive ownership in copying it, in changing it, in adaptation, in selling it, and all those things. So those who are even engaged in writing research papers, we suggest you get a copyright because it's very easy. Just take a printout, 2 printouts of the copyright, file online, and you can send it by post. That is enough. And then you can actually put it to the publishing house who will publish it in the journal. And one small, just a case, very interesting about a copyright infringement. It is a Super Cassette Industries and ASEAN Sujla channel in 2015. You know, this Sujla channel is a a local channel, just like that we have in Assam, Nagaland, other states. For this local channel, what they do, they take copies of the original content and they play it in their channel. There is a broadcasting. Broadcasting is also covered under copyright. And then what happened? The owner of these 3 songs, that is from Dabang, Tere Mas Donen, from Reddy, and from Tanuwel's Manu. So a complaint was registered in the T-Series company. T-Series is the Super Cassette Industries, and they had recorded the channel which is broadcasting these 3 songs, and these 3 songs, the copyright is owned by T-Series. And then they went to file an infringement suit in Delhi HC, and ultimately they won. And ACS has imposed about 5 lakh punitive damages to the ASEAN Sujla channel. So this is a very famous. You can read it out online. There are many things how things went there. So copyright, and in copyright, it's not only the civil laws come into effect. Sometimes repetitive copyright infringement, you can also claim some criminal infringement suits, so which is very dangerous, and you can land up to jail if you're doing all those activities like that. So this is the first part of about copyright, and next I will go to trademarks. And okay, so trademark is a symbol, it's a logo, it could be a name, combination of logo, name, some kind of a color, some kind of figurative element which appears on some goods, and by appearance of that you can say that this good is made by this company, or this good has got this type of certification, this is a such like a veg or non-veg type of product, and all those. So these are known as trademarks. Trademark should be very unique, and its criteria is distinctiveness. Distinctiveness in simple case, if you see a brand, say you're buying, say 2 kinds of biscuits are there. If you see the logo of the brand, then you should not be confused that whether this is from this one or this is from this owner. If you are not confused, these 2 trademarks are distinct. It's very simply. So any kind of customer when going, if you say, it also includes, say you go and buy this thing, you are selling something, that he or she should not be actually confused, then those 2 trademarks are distinct. Trademarks are written as 2 kind of things. One is the R inside a circle and one is a TN. If it's an R inside a circle, it means that trademark has been applied to the trademark registry, it has been registered, we have a registered certificate. TN means it is a trademark which has not yet been registered, but it is like a self-declared type of a trademark. And the Trademark Act is the Act of 1999. And interesting, you can see why I put this picture of a cow with an ear tag, because how the trademark started with such things. Because earlier they say in romance on the Greece, they use a sword. The sword was very special, so they used to put some logos there. Similarly, so trademarks come from the thing. It's like if you have your cattle, your herd of cattle in the field, then there needs to be earmark. Earmark means putting this tag into this ear. So he has to identify, oh, these are my cattle, these are some other, if they also mingle together. So this is the main concept of a trademark. Trademark has got 5 categories. The first is the word mark. It could be word, letter, numerals, just like you can say Sony, HP, Dell, all those. Then device mark, which could be a combination of word and combination of a design of a logo, any other geometrical figures, but it should be other than a word. It should not be a plain, but have some design like that. Then such as the Apple logo you have, then you have got a logo of Suzuki logo, Hyundai logo. Those are some kind of a device marks. Color marks are only combination of the colors, such as this. This is the Google Chrome, so it also goes into the color marks. Some kinds of our color marks are some channels like rainbow channels. Those are under combination of only colors, because there is no other things in there. Three-dimensional mark is very interesting. The goods that you're selling, you can also claim a trademark over the whole goods. Three-dimensional means all the pictures of the goods you have to give, and you can claim a trademark on them. Best example is the Ferrero Rocher chocolate. Ferrero Rocher is a registered trademark as a three-dimensional mark. The name Ferrero Rocher is a word mark that is also plus the whole chocolate, that is the brown, the casing and the upper golden part, everything is under the trademark as a three-dimensional mark. And also sound marks. Sound marks is the ringtones, then the small sound that you have when you turn on your laptop, and sound of wristwatches, and nowadays smart watches are coming on. Then all those things, small sounds, you can also put under trademark. But here limitation is about 30 seconds. To file a trademark, you have to use the form TMA, which it should contain the mark such as that HP or Dell or logo, whatever. Then class and description of goods. So where you will use that trademark. Is it a foodstuff? Is it some kind of a service? Is it milk? Is it some kind of an achar? Is it some clothing that you have to describe? And then if you have any kind of a certificates, like you're a startup, then small enterprise, you have to give it. If you have been using it for a long time, but now you're going to register it, you have to put an affidavit about its prior use, and then you have to pay a fees of 5,000 for individual startup, small enterprise, and 10,000 for others. Once this application is filed, nowadays everything is online in trademark. That will be checked for a formality, if everything is okay or not, or you will request some more information. Then it will be examined by the examiner and published in the trademark journal. If anyone has got any opposition, they can oppose it within a period of 3 months, extendable up to 1 month more. After that, if there is no any problem, then the trademark certificate will be issued to it. Along with the certificate will contain your logo or your trademark and the goods where it will use it. And from that day, you have got 10 years of time for the trademark. And interestingly, you can still renew it before expiry of the 10th year. From 9th year, you can renew for another period of 10 years. And some benefits of trademarks, it's mainly banning of the goods and services, and customer retention is the main thing of the USP. Originality and counterfeit safety and security in trade. So the example, as you can see, the above part is actually the infringement. So Starbucks coffee is a very famous, well-known trademark. So in Korea, they opened such a kind of a coffee shop that you have this logo. So it's a case of an infringement. So Starbucks is protected because they are a registered trademark and also well-known trademark. What about in India? These two biscuits you can find in the shop. They look very similar. The biscuits look very similar, but the trademark, that is, one is made from Britannia, one is from Sunfish, that distinguishes and also puts in a security in a trade. That yes, Good Day will taste like this, Mom's Magic will taste like this. So these two trademarks, they also protect and also create a safety in the trade of these two biscuit companies. So some other information, such as many types of trademarks are the standard that we have in the logos. Collective mark, if many people use together a trademark. Certification such as ISI certification marks. Series marks are there if you change a lot of trademarks together. Many trademarks together can resolve to one kind of application, that's the series mark. And interestingly, we all say in a trademark, I have been doing trademark work a lot, we say invented word are the best trademarks. You have to invent word, make your own word. Say you take one letter from your surname and other letter from your product and make it, then these are the best trademarks. So this is all for my presentation from my side. I hope I was being able to deliver as expected. And thank you for your time and for inviting me. Thank you.
Thank you, Mr. Siddhartho, for your presentation on copyrights and trademark and its benefits. We will come to you later, and now we'll continue with our next presenter, overview of IPR in Nagaland by Ms. Gyu Kalichishi. You can take your time.
Good afternoon, everyone. I'll be speaking on the topic of overview of intellectual property rights in Nagaland. Well, the former speaker have already talked about all forms of IPR, but I'll just give an overview of what IPR is. So what is intellectual property? Intellectual property rights are the rights given to person over the creations of the minds. They usually give the creator an exclusive rights over the use of his or her creation for a certain period of time. In other words, we can say that these legal rights prohibit all others from using the intellectual property for commercial purpose without the prior consent of the IP rights holder. It is an intangible property. Intangible means we cannot touch, feel, or see, but it adds value to a product. And it adds value to a business. And it can refers to a creation of mind, refers to creation of the mind. It can be an invention, that is product or process, literary and artistic works, design, symbol, names, logos, etc. IPR are largely territorial rights, and it can be assigned, gifted, sold, and licensed like any other property. IPR is time-bound, so you have to renew from time to time to keeping them in force. And this is the only right which can be simultaneously enjoyed in more than one country. So why intellectual property rights in Nagaland context? Well, Nagaland has a rich diversity of ethnic groups, languages, religions, climate and landscapes, and home to 18 recognized tribes with each distinct and fascinating culture. And Nagaland being one of the richest states in flora and fauna, IPR lacks its root in many areas which are considered to be the hotbed for IPR filing, such as geographical indication, patents, traditional knowledge documentation, etc. But many people are still unaware about IPR and their advantages in taking rights for their intellectual property. So slowly, people are infringing our indigenous and traditional rights. And since time immemorial, the indigenous traditional system has been passed on from generation to generation orally without any written documentation. And that is why various indigenous traditional knowledge and biopiracy methods are gaining the significance in the legal story of the country due to lack of proper documentation and an awareness of the IPR related issues among the local people. And this is where the PIC is trying to promote IPR awareness among the local people so that they know about what is IPR and how to protect the traditional knowledge system. And at present, cultural appropriation has greatly contributed to the endangerment of indigenous community and society. And this has been a matter of concern for a long time in the Naga society, maybe because of lack of awareness, and also a silent spectator on the part of the society has given a free access to our Naga cultural items and attires and traditional knowledge of system of medicines as well. And alarmingly, indigenous people are exploited through misappropriation in the name of culture promotion and appreciation. Many times we have come across our Naga attires has been misused and in the name of culture promotion and appreciation, and it's so unfortunate that it has been misused by our own Naga designers as well. So I'm sharing this screen. You can see in the picture. All I asked was, can I patent my copyright trademark? So in our office, we come across so many inventors, so many interested individuals who come for filing for copyright or trademark. They refer the term as patenting. Every term they use as patenting, they get confused with the word patent or the copyright or trademark. So people are still ignorant about kinds of IPR. So the former speaker have already talked about the various types of IPR, but these are the types of IPR: is patent, trademark, copyright, industrial design, plant variety, trade secrets, layout design, geographical indication. So I won't be going into detail, but I'll just give an overview of what is copyright. It is a type of intellectual property that gives its owner the exclusive rights to make copies of a creative work, and is intended to protect the original expression of an idea in the form of a creative work. It can be a literary works, dramatic, music and artistic work, motion pictures, audiovisual works, cinematograph films, and sound recordings. So every IPR has a time bound, and in case of literary work, is protection is lifetime of the owner plus 60 years. In case of artistic work, the term is 60 years. Broadcasting, the term is for 25 years. What is trademark? Trademark can be any device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, or combination of colors, or any combination thereof. So trademark helps you to distinguish the goods and services of one person from those of others. The term of protection is 10 years and can be renewed indefinitely by paying renewal fees. Industrial design. An industrial design is an IP right that protects the visual design of an object. So it protects the appearance or aesthetic features of a product. It makes an article attractive and appealing, which adds to the commercial value of a product and increase its marketability. It can relate to a feature of shape, configuration, lines of colors, pattern, ornaments, composition of lines of colors applied to any article in 2D or 3D or both forms. The term of protection is initially for a period of 10 years and can be renewed for another 5 years by paying renewal fees. So this is just an example of an industrial design of a Coca-Cola bottle. So this Coca-Cola bottle, it is started in 1899, and till date, you can see the physical appearance of a Coca-Cola being changed, but it is all protected under industrial design. And in this case, this is a very famous case between iPhone and Samsung smartphone. So this Samsung and Apple, they sued against each other in more than 10 countries, and the case was for 11 years. And you can see in the picture, Samsung smartphones, they appeared before iPhone, and with that designs, the physical appearance design. And after Samsung, Apple iPhone was introduced in January 2007 with a protected design. And you can see in the last picture, Samsung smartphones, they have copied a similar type of designs to from Apple. So they had a case between each other in more than 10 countries, and the damages were awarded to Apple of $539 million. So you should be very careful in using someone's protected design. If he or she wants to use, the company wants to use the similar type of design, that they have to get a permission from the respective owner. Next is layout design of integrated circuits. Layout design of an integrated circuit refers to essentially to the three-dimensional character of the elements and interconnection of an integrated circuit. So integrated circuit rights are simply IP rights that aims to protect the original layout design for integrated circuits and computer chips. And it can include a layout of transistors and other circuitry elements and include leads wire connecting such elements. So the term is 10 years from the date of filing. Plant variety protection and farmers' rights. It is a system for protection of plant varieties, the rights of farmers and plant breeders, and to encourage the development of new varieties of plants. So it acts as a certification of registration for a variety and act as an exclusive rights on the breeders or his successor, his agent or licensee to produce, sell, market, distribute, import or export the variety. So in case of trees and vines, the term is 18 years from the date of registration. In extant varieties, 15 years from the date of notification, and in other crops, 15 years from the date of registration. These are some examples of plants variety protected. This product, the golden variety of custard apple, got plants variety protected, and it was produced by Solapur-based farmer Navnath Kaspate. And in the next picture, the groundnut, Dhiraj 101 groundnut, was developed by Dhiraj Lal Tumar, and it is also protected under plants variety protection. Next is trade secret. So trade secret is IP rights that is a confidential information which may be sold or licensed, and it can be formula, pattern, business information, customer information, methodology, strategic plans, etc. And it has a commercial value and only known to a limited group of persons. And it has no time bound, it's unlimited duration as long as it's a secret. And it is automatically granted, no legal action required. So you can see in the picture, the famous trade secret is KFC recipe. This KFC recipe consists of 11 herbs and spices, which was developed by Garner Harlan Sanders in 1940s, and this handwritten recipe is stored in a bank, protected in such a way that other companies, other competitors wouldn't know of it. And the next picture is a Coca-Cola. The formula of Coca-Cola is a trade secret, and it has also been a trade secret since 18th century. And in one cases in 2006, a Coca-Cola employee and his two accomplices have tried to sell the Coke recipe to Pepsi, but unfortunately the three people were caught by the police because the Pepsi notified to the Coke regarding they were trying to sell the trade secrets to Pepsi company. So they are protected in such a way that it is not they have to sign a non-disclosure agreement that they will not reveal their trade secrets to others. So patent. Exclusive rights granted by a government to an inventor or applicant to make, use, and sell an invention for a specified number of years. It prevents others from making, using, selling, or distributing invention without your permission. So criteria should be novel, inventive, and capable of industrial application. So patents are territorial rights. Territorial rights means you can file in any parts of any other country, and the term is 20 years from the date of filing. I'm not going into detail in all these patents, trademark, copyright, and trademark, since the former speaker have already spoken in detail. And geographical indication. Geographical indication is a name or a sign used on certain products which corresponds to a specific geographical location or origin and possesses qualities of our reputation due to that geographical origin, and it acts as a certification that the product possesses certain qualities and is made according to traditional methods or enjoys a certain reputation due to its geographical origin. Duration of protection is 10 years, and every 10 years you have to renew it. So we have 4 GI from Nagaland, that is Naga Mercha, Naga Tree Tomato, Chakasang Shoals, and Naga Cucumber. This was recently granted in September 2021. So we have 4 GI from Nagaland. This is it's just citing an example, like the traditional attires of our Naga people have been misused in big platforms, in fashions, without giving acknowledgement to the owner, without taking the permission from the society. It has been misused inappropriately. So due to the occurrence of such cases, the Naga people are now, they are waking up to file for GI in all the traditional attires of the other tribes. And this is also another case of Chakasang shawl being misused by designer Ritu Berry, and she has showcased her this fashion in Surajkant Mela and Haryana last year on February. And this Chakasang shawl is a GI shawl, and she has not taken the permission from the Chakasang Women Welfare Society, who is the owner of this shawl. So it has really hurt the sentiments of the Chakasang community and the Nagas as well, since these shawls has a significant meaning behind it, and it is a taboo to use by everyone, and it has been showcased in this kind of events without giving a proper acknowledgement to the owner, or taking permission from the owner. So the Chakasang Women Welfare Society has filed a lawsuit against Trifit and designer Ritu Berry, and this case is still ongoing. So I'll come to the activities of what our Patent Information Center is going on. So we were established in 2011, and this is the only organization in Nagaland dealing with IPR issues. This was set up by the Department of Science and Technology, Government of India. And PIC is the nodal coordinator for IPR in the state, and also coordinator under Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry. Our objectives of the center is to create awareness programs and consultation resource person among the people in the state, to facilitate universities, industry, government department, and art institution for patent filing and searches, GI registration, copyrights, new plant varieties, etc. We also set up IPR cells in universities and our Institute of Higher Educations. We provide free patent searches. So 5 IPR cells has been set up, that is NUC Dimapur, Patkai Christian College, Nagaland University, Khoima Science College, and Department of Industries and Commerce. So our annual activities are, we create awareness programs and IPR to schools, colleges, NGOs, entrepreneurs, departments, farmers, etc. And we also go as a resource person to the on the event, as well as we invite guest speakers for IPR awareness workshop. We facilitate in patent filing and searches, GI registration, copyright, trademark, new plant varieties, etc. We also carry out patent search through Procure database, and we conduct post-GI awareness workshop. Since we already have 4 GI, but we see that people are still unaware of what is this, this GI, the granted GI can do. So we have been creating GI awareness workshop to the farmers, to the entrepreneurs, and to the local people. So we conducted patent search for around 20 innovators, and we have been guiding innovators in copyright and trademark filing. So these are some of the annual activities of PIC. These are the activities which we have given an awareness workshop in the NABARD, in the schools, in the colleges. these are the activities which we have performed, and the awareness workshop which we have done in Loinglum Festival. We have set up a IPR cell, as well as in the startup programs. We have visited schools and colleges for the workshop. These are the workshops conducted on IPR for the colleges. And we also conduct webinar seminar during the pandemic. So these are some of the webinars we have conducted during the pandemic. And we have also conducted IPR games. And the post-GA awareness workshop we have conducted in more than 3 districts. And we also conduct state level workshop where our eminent resource person, the former speaker, Dr. Arvind Chitra, has also has been a resource person for our state level workshop. And other activities, like we have documentation on Naga traditional attires, designs, motifs, ornaments, and GI tagging of 18 inhabited tribes of Nagaland in collaboration with Nagaland Handloom Handicraft Development Commission Limited as the implementing agency, and PIC is acting as a facilitator and providing technical assistance. And due to the heavy exploitation of our Naga attires by outsiders, the government of Nagaland, with the initiatives of our Chief Minister, has taken a key interest in filing of GI of all tribes of Nagaland in traditional attires. So this is the ongoing documentation which the PIC is trying to facilitate all the 18 tribes of Nagaland in getting a GI tag. We had an orientation program on documentation for the researchers for this documentation on traditional attires. They were taught how to do a research on the traditional attires and do a documentation, so that in the later time we can file for GI of all 18 tribes. So right now we are documenting on the traditional attires, motifs, designs, and ornaments. And in the second phase, we are trying to document on the handicraft, so that the handicraft also can go for filing of GI and get it protected. So in conclusion, intellectual property rights are monopoly rights that grant temporary privileges to all the holders for the exclusive exploitation of income rights from cultural expressions and inventions. So understanding the country's IP rights and following the best practices can reduce the risk of losing one's own protected property. Thank you.
Thank you, Gyukaritisi, for that wonderful presentation. And now we are on to the discussion session. And any participants can ask any question. But I'll start off with a question. You have already highlighted the question will address to our 3 speakers, Madam Chitra and Sir Devnath and Shikara Sogi. The recent visit of our finance minister has stressed on the issue of trademark and branding of organic products. So how and who should do this, and how should we do it? That one we are asking. First, I think our Madam Chitra can answer that a bit.
See, trademarks. First, we have to understand what are the products, whether they are something which is new or which is old. If it is new, like something which you have made right now and it's like a company, and then we should go for trademarks. Otherwise, if it's going to be on traditional knowledge, I would recommend that first you file it as a GI and take a collective mark as a trademark and use it for your community. So the word organic alone will not suffice. The word which you have to check whether it is traditional or modern.
Okay, thank you,
Dr.
ma'am.
Devnath, you would like to add something to it?
Yes, ma'am, I completely agree with you. And also regarding the marks, actually, from Nagaland, we have got a lot of products from there, and especially Naga Mircha products are in Assam also that we are also buying. But there is no actually the GI, that authorization is not there. There are no authorized users too. But till we can have some authorized users, just like ma'am said, yes, a collective mark can also give a good amount of protection to this. And also we may have some a certification mark also regarding the Naga King chili, because the chili we don't get it in the shops here, but we get the achar of the chili. So there in the achar, if we can have a certification, some kind of a related to the GI application, then I think the people from Nagaland can have a lot of benefits out of it. So that will be my submission.
Okay, thank you, sir. My question is, who should be doing all this GI regarding the organic products?
Again, it has to be product by product. If it is a GI, the registered user is supposed to do it. Okay, at least earlier it was such that the authorized user had to take permission from the registered user. It is not so anymore. People can apply for authorized users separately, but the registered user has to make effort to contact the authorized user, ask them. Okay, tell them that this is my GI, this is the knowledge which is associated with GI, this is the mark. So please, use this mark. And all these things have to be, contractual. So the registered user has to take this effort to contact authorized users and, control the supply chain.
Okay, thank you, ma'am.
Yeah, may I add something about this regarding the GI application? We have in Assam also we've got a lot of GI applications, and what we are doing now is that when we get a GI application we are working on, we are holding a meeting of all the GI stakeholders together. For example, we are doing on Assam tea now, so it will be a special only for CTC. So we are calling all the tea industry people together, and this initiative can be done by the PIC only. The PIC, in our case PIC STEC, and in your case PIC NESTEC. So if they call a meeting from the government, from the private, then the associations, and then you held a meeting with discussing that we want to go for GI, this and that, then who will be the applicant? Because in GI, we know an association of persons is the best applicant. If it's a government, there is a problem with fund and maintenance. If it's a private, there is a problem with, they will take over whole the GI capturing type of problems. So if we can do some meetings, because we are doing currently, and it has been very fruitful, then when someone comes forward, then we decide their credibility based upon the minutes that we draw from the meeting. And then later on, we say that, yes, this will be the applicant. We will get it to approval of the government also. And then the applicant comes into some kind of a binding that applicant has to do business and also issue consent letters, register authorized users under the welfare of the people. So I think that the answer that sir has asked me, who will be the applicant, I think you can make some meetings like that and design the parties who are actually working. I think that will be one of the best suggestions.
Thank you very much, sir. We have understood.
Yeah.
Okay.
Yeah. In between, I just want to come in. Yeah. Thank you to both of you for highlighting this issue. But I have one concern here. I mean, like, Madam Chitra, you have highlighted that regarding for the user registration, now the new clause has been added that where the user doesn't need a permission from the proprietor anymore. So I'm a little bit skeptical here, in case without the permission from the proprietor, if everybody start registering, And if they start selling the product without the knowledge of these people, then what will be the, wouldn't there be some conflict there?
The authorized user is supposed to follow all the rules and sell as per what is present in the GI application. They are supposed to use the logo which is there in the GI application.
Yeah.
Okay, so if the authorized user, even if they are independently registered, is not doing this, then the registered user has to send notice to the authorized user. Okay, so we have to ensure that the authorized user is doing this. The onus still lies on the registered user, but we have to keep track of what is happening.
Yeah, because the case for the Chakasan show, the proprietor, the authorized proprietor is the CWWS, but now recently the trifecta have registered as one of the user, and it's not in the knowledge of the PIC nor with the CWWS. So
it is updated in the site, okay, and Trifect is an authorized user there.
Yes, I have seen that.
CWWS has to approach Trifect and understand, because still the registered user has the right. They have to ensure that these are the rules in which Trifect follows. There has to be written communication to tell Trifect that this is what is expected out under GI in records. Okay, and if Trifect does not follow that, then we have a cause of action. But see, a GI is otherwise, a GI gets diluted. We don't want, the authorized user to do a passing off, but it is necessary for the registered user to be cognizant. Okay, we have to make attempts to give rules. We have to give attempts to regulations. Okay, so if there are many producers, it only helps. But you need to collate your supply chain, ensure that anything which comes out of a certain place is forming a certain quality. This is the place, there is a inspection body in your GI application. Okay, so this inspection body has to take a lot of precedence. The inspection body has to be very active. It cannot just be on the paper. So if there are 2 or 3 sources where your GI is going to reach the market, the inspection body has to ensure that everything that goes is authentic. There is a logo which is placed, and there are no, passing off or spurious products there in the market. Okay, this requires teamwork. This requires community knowledge. But again, I would request the registered user to make a draft email and reach out to the authorized users for every GI. This is going to be true for every GI that you own.
Thank you, ma'am. Any other questions from the participants?
Yeah. And regarding this GI, now in Nagaland we have 4 GI. So my question here is, how do we trade the path? That is, how do we trade the market linkages? How do the farmers get benefits of this GI product? Because Siddhar also was mentioning that in Nagaland we have GI, the Nagamercha, which is already GI tag, but the farmers are not getting benefit fit in. So in fact, the GI mercha that is going to Assam and it's promoting in that in the other brand name and all. So how do we, the producer, the farmers, get benefits? What is the path that we should create in order the farmer to have the avail the benefits?
Dr. Devnath, you want to take this? I can add on.
Yes, the thing is that, Madam, I'll just share what we have done for Muga Silk. No? The one thing is that once you register a GI, even like your state, our state, no, the people who are actually manufacturing, they will never come to your office. They will never come forward practically to get themselves registered as authorized users. I think we have to take the first step. Example, we have done some GI authorized user registration camps. So we take out from some dedicated fund and we do some workshop where we go visit them, find out who are actually doing the work, and then sensitize them beforehand. And then one day we held a meeting, and in the meeting we take all their credentials and then we draft their authorized user application, including fees and everything, and then we send it to GI register. Because since it happens to the authorized registered proprietor, so we only verify it at our end. So then the GI registry does not object it. In this way, initially we had registered about 14, 30 like that registrations. And there was a mass drive that was created by Tezpur University, where that registered is almost like 70 and another 70 type of. After that, when it is popularized a little bit, I think, ma'am, it automatically comes. But now, currently, in case of Muga, we are not doing any, GI camps till now. But people are coming every year. We are getting 3-4 people coming. They are getting registered. Then sometimes the government tells that this is a program. We go and tell. We get 10 to 20 people from there. So I think initially, madam, we have to give a kick, have to take an account about spending our own money and all those things. The registered proprietor has to take a step. And then there is no other department in our case. Our concerned department is, say, Directorate of Sericulture. Sericulture, if they tell the people to come to Aztec to register as an authorized, they will not come. So we have to go there and do some work from ourselves, get some people registered, then only, madam, I think the authorized users will come. And regarding the branding, what is coming on, so those people who are getting registered, we have been in constant contact with them. We when they sell something, and when there is recently now there is a GI fair going on, people are calling me from all over that we want to participate. Then you do this form, you fill up this form, you need GST and all those things. Madam, this extra work has to be done by the registered proprietor. They will not do themselves. So I think it is a, even though people say that being a registered proprietor of a GI is a proud thing, but I think there is a very much work at the backside that we are doing. And for this, I think we can have a success of.
Yes.
To add on,
thank you.
Dr. Devnath made a very valid point. To add on to this, ma'am, first you need to generate funds. Okay, once you generate funds, you need to have a mechanism for disbursement of funds to the producers. Okay, so why would the producers come to you if you don't give them something a little bit plus? Okay, either it is a premium price, or say, for example, it is a safety mechanism or a net. Like, in Tirupati, that's a temple, that's a famous temple in Andhra. There are a lot of people go there to pray and shave their heads. Okay, so even though it's not a GI, but the use of the hair for producing enzymes and everything are there. They're the people, the barbers, okay, they have a safety net, they have a pension, they have a retirement age. Okay, so these are safety nets that we give to people. Okay, so tomorrow, say for example, you have a source from a plant source from which you take, the plant and make the shawl. Supposing there is that plant source has been destroyed or something. Okay, so those shawls cannot be made. Do you have a safety net of a cultivation of those plants, both to save the environment, or if a person or if a lady is not able to make any shawls, do we have, some mechanism to tell her that you will be taken care of in your bad times?
Yeah, thank you, ma'am. We have Vaibhav Jain. We have Vaibhav Jain raising his hand. Sir, you have any question? You can ask the question. Vaibhav Jain.
Yes. Am I audible?
Yes, you are audible.
Yeah. Good afternoon. My question is, can a software or a algorithm which can perform better result or have a different result can be like a copyright or patented?
Actually, software in case of India, software, if you say per se, if it's a computer program, you can go for only copyright, not patent. But if the software is kind of embedded with kind of hardware, then some methods, that is the algorithm in the software, may be patented. So this is depends on the trick and the the ability of the attorney or the agent how to write it. But normally, no software is patentable in India. But I'm giving an example. Software relates to, I think you are maybe talking about apps, the Android apps, then iStore, Apple apps. So those apps we have facilitated a lot. All you need to do is, in case of an Android, you need to get the source program. It is written in Java class. So you need to get the Java class, and then all those programs, you have to make it into a readable document or a file, and then you have to compile them and also get the object code. All those two things together along with your app, that is the APK, you burn it into a DVD and send to Copyright Office for registration as a software port. And then they will keep one copy, they will return you one copy, then this is how you get the registration. And in case of patents, if you're developing a software which is required for your invention to function, for example, say the washing machines, they have got an embedded system into it. So those, in that case, you can also claim that there will be a sensor which is controlled by the amount of water that will be in the water level, and this triggers the inlet of the water, outlet of the water, like that. The writing of the claims, that also you can patent some software related inventions. We call it as CRIs, computer related invention. There is a manual also in the patent office website. You can check it out, sir.
Sir, means like if the source of information is being obtained by some government agency using the APIs, and then using those data and processing it and using the algorithm, and which can perform a better result. So those things, it can be copyright or not. My question was that.
Yes. You can copyright them, no problem. But one thing is that even in case of government work, those who have actually created their work, you have to take an NOC from them. For example, if someone is third parties, you are giving the money or outsourcing it to make the software, and then they are making it and all the APIs they will submit to it. But you have to take an NOC from them, and then you can file for the copyright.
Okay, sir. Thank you.
Yeah, before we wind up, I just have a small request to the Devnath and Chitra. Recently, yeah, we have facilitated and we have done some user registration of the GI. So now I feel that the GI user, I mean, the business model has to come up. So yeah, very soon, yeah, if you can kindly guide in this, that will be very helpful to the farmers. Yeah, thank you.
You can take it first, Dr. Devnath.
Yes,
you have practical experience.
Yes. So business model is that, ma'am, what you can do is that the bunch of authorized users that you have, you need to promote them. For example, today you are at Bhopal. So there, take some products from those things. I know it may be a little bit unofficial. You are not going to sell it, but for sample distribution type. If there is any program in your private program, a government program, please call the authorized users. You have to pay their TADA. So this is the initial, you have to do it, madam. Once they will come to know about that, yes, these and these things, you can sell it over there, then their business model automatically comes up. And next, I can suggest one thing. You can organize some kind of a festival type, small festival, that GI festival of
Yes.
Nagaland, where you can showcase all the GIs, and then you call all the authorized users to put their stall. So there will be a condition that only authorized users can put their stalls. Regarding the price, they can fix. I think you can fix a price ahead about 10 to 15% ahead, because it is a GI product. So by using that, madam, I think you can build up a small business model and publicize it. That I think will have a good start. Over to you, ma'am.
Thank you, sir. What I also say is there are some mechanisms which are available like GI stores. Okay, there is, state-owned stores for various states. Okay, ensure that we have tie-up with this state-owned stores and also GI stores. Your product is available. See, while we understand the sensitivity of the shawls, okay, and inside Nagaland, that sensitivity is well known, but we need to educate other people also. So for every shawl that you want to have a sensitivity, please write a small story about the shawl. Okay, that this is to be worn by women, this is to be worn by people of the society. Like your Hapidasa shawl that I understand is worn only by people who reach a certain status in the society. In those days, kings, but in nowadays, people with a very great, achievements. So price it accordingly. See, people who have very great achievements would have made their money or their name in the society. So if somebody wants to present somebody or tell them that like you are the king, or we understand that you have done it, price that shawl for a higher value. Okay, so and you have a story for it so that it's your authenticity also does not get diluted and our emotions also don't get hurt. So that you say 3 lakhs, 4 lakhs, 5 lakhs for that shawl. So which means that not everybody is going to own that shawl, like your pashmina. Okay, so for some shawls which are worn by bachelors to attract girls or young girls to show that they are not yet married, price it differently. Okay, and you tell that you can even write it's lucky that you will get married. So people who want, that's writing language, and that's language is what you need to get it protected by copyright. Okay, so those pamphlets, those leaflets, you put your Chakisoin logo into it. Okay, so are your products which are going out with a logo sewn on the shawl or not? Okay, so if you have a logo and it is sewn on the shawl, then we will be able to identify the origin. You put a packet and put a sticker on the packet, I tear the packet and throw it, your logo goes along with it. Okay, so and is there any way to trace that your logo is the authentic logo? Okay, so these are things that you can think through. Okay, so once we know that this is a source, then it becomes easy for us to enforce products and enforce a logo for what is not there in the source. Okay, so if we have people to appreciate what our shawls are, we have to educate them. Okay, within your community, your grandfather must have taught you, you will teach your children. But outside your community, we need to educate, we need to take the pains to do that. For people who have Hapidasa shawl and who can afford it, or I want to gift it to my father who's reached a status in life, and I'm willing to spend that 3 lakhs. I want to give it as a gift, So what is your packing? How is it packed? Okay, and how do I translate that significance to him? These are things that you have to think through. Okay, look for a marketing personnel along with all your workshops and everything, and this needs to be taken on a very serious note. Have some rules, regulations, and passed on to community.
Okay, thank you, ma'am.
Thank you. Yeah, thank you for the inputs.
I think if there is no further questions, we will end this last session of our celebration on Vigyan Utsav. We want to thank especially the SSTP division, DST, Government of India, for letting us host this last event. And we also in particular want to thank our Sir Dr. Yash Shawant and Dr. Shikha Rastogi, Dr. Chitra Arvind, and Mr. Siddhartho Devnath in particular for giving us a good presentation today. And we want to thank all the participants in this event, and thank you all.